You've been wondering whether you're entitled to maintenance, how much, how long it'll last, and how it can be stopped, and you need help. Hello, my name is Attorney Danielle Pinkston. I'm owner and founder of Pinkston Law Group, and welcome to What You Should Know Wednesday. Our topic today is maintenance or spousal support. In Illinois, maintenance or spousal support may be awarded to either spouse by agreement of the parties or order by the court in conjunction with a dissolution of marriage proceeding or legal separation. The judge has the discretion in determining what type, duration, and amount of maintenance he or she deems fair and equitable after consideration of other relevant factors. The first factor is the income and property of each party. 2. The needs of each party. 3. The present and future earning capacity of each party. 4. Any impairment of the present and future earning capacity of the party seeking maintenance due to that party devoting time to domestic duties or having foregone education, training, and employment during the marriage. Number 5, the time necessary to enable the party seeking maintenance to acquire the appropriate education, training, or employment, and whether that party is able to support him or herself through the appropriate employment. Number 6, the standard of living established during the marriage. 7, the duration of the marriage. 8, the age and physical and emotional condition of the parties. 9, the tax consequences of the property division upon the respective economic circumstances of the parties. 10, contributions and services by the party seeking maintenance to the education, training, career, and or career potential or licenses of the other spouse. 11, any valid agreement between the parties. And number 12, any other factor the court finds to be just. Therefore, if you are the party seeking maintenance, you want to thoroughly study these factors to be sure you have the power or you have the knowledge and know-how to what you have to do to persuade the trier of fact. You should know how to use these relevant factors and apply them to your life to prove to the court or the judge that you are entitled to maintenance for these reasons. Contrary, if you are the payer spouse or the one who is supposed to be paying alimony or spousal support, or maintenance, you also want to know these factors to be able to persuade the court that, again, the person who is seeking maintenance from you is not actually entitled to it. So, you're now wondering, what are the various types of maintenance? The first one is called rehabilitative maintenance. It's awarded for a set and relatively short amount of time after divorce, and the goal is to provide the spouse with financial support while he or she pursues education, training, or development of skills that will enable him or her to re-enter the workforce and or become self-supporting. Next, we have what's called reviewable maintenance. It's structured just like rehabilitative maintenance in that it envisions the recipient spouse becoming financially independent after divorce. However, the court will review whether this has happened or whether this recipient spouse has taken steps to become more self-sufficient. Lastly, we have permanent maintenance. Just like its name implies, permanent maintenance is awarded to a spouse after divorce for what can be proven to be a prolonged period of time. However, it's important to understand that, again, this maintenance can and often is reduced or even terminated for various conditions such as remarriage of the recipient spouse or retirement of the paying spouse. So now you're wondering, how does a court even calculate maintenance or spousal support? Well, in Illinois, we now have a formula the court uses, and if the parties make under $250,000 a year, they will use this formula. And it's as follows. The court will take 30% of the gross income of the payer spouse, the one who is to pay maintenance, and subtract that by 20% of the gross income of the spouse who is to receive maintenance. That equals the amount of maintenance to be paid per year. So you're wondering, how long will it last? Well, the court has another formula. Essentially, if the parties are married between 0 and 5 years, the court puts them at 20%. 5 to 10 years, 40%. 10 to 15 years, 60%. 15 to 19, 20 years, 80%, and over that, again, determined by the judge. The judge will determine what it should be because, again, you've been married for an awful long time. You're thinking, why are you even getting divorced? No, just kidding, just kidding. So, say for instance, in our first scenario, we have the spouse who is to pay maintenance. Their income is essentially very high. And then 30% of their gross income is $60,000. We subtract that by, again, the person who is to receive the maintenance, and their income is $6,000. So we have $60,000 minus $6,000 equals $54,000. Okay? So in this scenario, the parties were married for 15 years. So we then take 15 years, or 15, multiplied by 80%, which equals 12 years. Therefore, in this scenario, the person who is to pay alimony pays for 12 years at $54,000 per year. That's a lot, I know. So we know how to calculate maintenance and support, but how can it be terminated? Well, the answer is quite simple. Unless maintenance is in gross or a lump sum or is otherwise agreed upon by the parties, future maintenance terminates upon the death of either party or if the receiving spouse remarries. Maintenance may also be stopped once the receiving party cohabitates with another person that is not their spouse. Okay? Maintenance can also be suspended or stopped if the pair spouse is in prison. Also keep in mind, Illinois courts have also stopped rehabilitative maintenance where it was originally awarded to allow the receiving spouse to seek employment opportunities or to obtain further education or training to become self-sufficient. But again, that court found the person was not taking steps to actually do that. Again, the court does have discretion to stop and start or reduce maintenance if various factors or conditions apply. That's all my time for today. I hope our segment was very informative for you. If you still have questions, contact my office at 773-770-4771. Again, 773-770-4771. Or you can schedule a consultation online at pinklaw.acuityscheduling.com. Again, pinklaw.acuityscheduling.com. Keep in mind, What You Should Know Wednesday is never intended to take the place of a one-on-one consultation. So if you have additional questions, contact my office as soon as possible. Thank you for tuning in, and I'll see you next week for What You Should Know Wednesdays.